Hi everyone, you're very welcome to our webinar today, and thank you for attending on this blustery day wherever you are. I myself am in the wilds of Donegal, and my Wi-Fi is a little bit unstable, so if I'm prompted to do so, I may turn off my camera to make sure that that you can hear me well enough. So my name is Sarah Neil-Loughlin. I'm from D-Connect, which is based in Dundalk IT. As I was showing a slideshow before the webinar began to tell you what D-Connect does. I'm just going to briefly talk you through that slideshow, if I may. So we are the National Digital Health Innovation Hub. We support innovation in digital health through knowledge sharing in our connected cluster, education and training programs, through business supports, advice, mentoring, helping companies with digital transformation and internationalization, reaching the national market and also the international market. The series we're in at the moment is called The Nuts and Bolts of Developing a Digital Health Product. So far in October, we covered interoperability, medical device regulation, and building your product around customer needs. Today is intellectual property and patents. Next week we have GDPR and privacy, and we will finish off on the 16th of November with cybersecurity. In the new year, we start our new program. It's a scale-up program for companies that are a little bit more advanced. And we run it in collaboration with the Connected Health and Wellbeing Cluster in DKIT and with Amazon Web Services. Amazon Web Services can provide considerable technical support on that program to companies who wish to scale up their infrastructure and move to a cloud infrastructure so that they can scale their technology. We also work with companies who perhaps want to move from white label to a version of their technology that they can manage themselves without having to outsource the technology. And therefore, we work on low code and no code solutions. Other topics that we cover are interoperability. And as you will know, if you're involved in healthcare, the Irish healthcare system uses SNOMED CT as its interoperable IT infrastructure. We also cover procurement, medical device regulation, cybersecurity, and all things data, among other topics. So if you wish to have more information about that program, please do drop us a line on support@dconnect.ie. You can find more information about all our services on dconnect.ie. So today I'm very happy to be joined by Catherine Hanratty, who is a patent attorney, and Conor McCormack, who is going to talk to us about MCOR Technologies, a company which he founded in the noughties. Conor will talk to you a little bit more about the detail in a moment, which had IP and patents in the area of 3D printing. I'm going to ask Conor and Catherine to turn on their cameras now and join us, please. Hi, Conor and Catherine.
Good morning, Sarah.
And Conor, I know that you're a man of many talents, and when I introduced you, it was in relation to MCOR Technologies that you're now AD Astra Consulting. So when you join us in the second part of the webinar, Conor, please do feel free to give yourself a proper introduction, because I know that my introduction was a little bit lacking. Catherine, you are with Murgatroyd Solicitors, and you're a patent attorney. That's your correct title, am I right?
That's exactly
so.
It, yeah.
Catherine, I think without further ado, I'm going to hand over to you, and then we will move to Conor's personal professional story through the landscape of IP and patents, and we will have time for Q&A at the end. So for our participants, you will notice that the chat is not enabled for this webinar, that we're using Q&A as a method of communication. So if you pop your questions into the Q&A, we will address them to Catherine and Conor as we go along. So Catherine, I'll hand over to you, and I'm going to turn off my camera.
Okay, well, thank you very much, Sarah. and the team at DConnect for inviting
Catherine, I
me.
think you're still muted. We can't hear you.
Okay, sorry about that.
I could hear you, Catherine.
Yeah.
Okay, yeah, I can hear you now too. Yeah.
Oh, okay. All right. So, well, anyway, just Sarah, because the thank you was to you, I will repeat it. So thank you very much for inviting me along to talk about IP today in the webinar series, Nuts and Bolts of Developing a Digital Health Product. I would feel that IP fits very well and can be described as nuts and bolts, similar to product approval or regulation or authorization. IP can be quite technical and also have strong formal and procedural aspects and requirements. So I hope to give a brief introduction to IP and points to consider when developing a digital health product. So in brief, I aim to cover what is IP, why protect your IP and how to go about identifying and protecting that IP, the various types of rights, developing an IP strategy, and a little bit on IP in the digital health field as it looks today. It's a field of major growth, obviously. So first of all, what is IP? Well, we have, I guess, many definitions, but one definition from the WIPO, World Intellectual Property Organization, it describes IP as relating to creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, images used in commerce. So we're talking here and focusing on intangible assets based on creativity and innovation. And this extends through to brand, which works as a hallmark of reputation, trust and quality for the IP holder. So IP supports innovation. It can be protected through registered and unregistered rights, and IP provides that those who invest in innovation can share their work while protecting that investment. So why protect IP? Well, on the nuts and bolts level, the aim is to use IP as a tool to support growth of the business, and this is achieved ideally by implementing an IP strategy. And this should be maintained in alignment with commercial goals of the business as it grows. So this image here, I thought it was quite nice. It highlights some of the aspects around the use of IP as a tool. It comes from the Intellectual Property of Ireland's Patent Office website. They've many useful resources there, but in particular, I like this one. So a successful commercialization of an innovative technology must be guided by a clear IP strategy that is aligned with other key functions of the business. So the IP strategy should underline financial, risk management and product roadmap aspects of the commercial goals of a company. In some ways, the IP strategy is considered as a bit of a business plan that provides you with the guidance on how to protect and use IP assets to achieve specific commercial goals. If you operate in a highly innovative or competitive field with many players, you should definitely consider using IP to protect your solutions. On the financial side, having IP assets increases a company's valuation. It is an asset on the balance sheet, albeit intangible, and it is an asset that can be used to attract investment, to secure funding or credit, and to build new revenue streams via licensing or sales, and to strengthen positions for negotiation in the commercial sphere. In terms of risk management, IP supports protecting market share, ideally essentially working to exclude competitors. And having an IP strategy in place provides a mechanism for increasing awareness of the competitive landscape and of what competitors are doing and managing that in terms of your own product development. An IP enforcement is something that can be used as a fallback in the event of infringement. And also having an IP strategy in place allows consideration of freedom to operate. So all these aspects of managing risk as you move forward with your product. It also supports the product roadmap, and it gives ideally a competitive edge and supports innovation, and it can be expanded as new products are added and new markets are added. So overall, the IP strategy should be aligned with the business strategy and support the business as it expands. So in recent years, there's been quite a focus on SMEs and the value of IP for SMEs. Studies from UAPO, the EU Intellectual Property Organization, and the European Patent Office have tried to quantify somewhat the value of IP for SMEs. And we know in general, but also from these studies, that in the EU, a massive amount of commercial activity is focused in SMEs. They're looking at something like 2/3 of employees work in this sector, and the vast majority of firms are SMEs. However, the study showed that only 9% of SMEs have IP, whereas 60% of larger organizations would, and then went on to quantify some of the value of IP for SMEs. And the study showed greater revenue as a result of holding IP. So there's a good commercial value as well to having IP. So just to take a moment and consider an example of when innovation occurs and where we find innovation and IP. Innovation is often considered as occurring in two main phases, so the innovation phase and the commercial phase. And protecting your IP gives you the chance to level the playing field with your competitors, no matter their size. Innovation is the process of translating an idea into a product for which customers will pay. The innovator is often the first mover, the first to market, which can have an advantage. However, they will have assumed the risks and the costs of R&D along with the benefits. Competitors may try to enter the market as a fast second mover. They have an opportunity maybe to develop an alternative or better product and carry less risk because the market has already been established. During the innovation phase, IP is created and the IP is ultimately manifested in the product or process that will become a real market offering. And it is crucial to try and protect this IP. For this reason, it is another strategic tool in the development of a product. So often patents, copyright, confidential information, such as trade secrets, will play an important role in the early phases of the innovation cycle or innovation timeline, whereas trademarks and designs come into play in the commercial phase of the innovation process, where products must be distinguished from those of others and the brand is established. And if IP is not protected, then competitors could more easily copy a technology or process and gain some competitive advantage in the market. So looking again at an IP strategy and just taking account of the timeline of innovation as well, we often consider the IP strategy as covering three main pillars or phases. The IP creation phase, which would include innovation capture and IP to product mapping, where there's a focus on a product and consideration to what could be protected and how best to protect it. The next phase is the IP management phase, which includes working on registration of rights. These could be filings for applications in patents or trademarks, but it would also include managing internal procedures for protection of know-how and trade secrets. And then later down the line, the IP activation pillar relating to valuation, licensing and partnerships and so on. So in terms of where to begin, we would often recommend an IP audit is a good starting point. It's a useful place also to start for developing an IP strategy or for reviewing periodically to modify an existing IP strategy. So as discussed above, the IP strategy should develop as a business develops and move along in alignment with the business objectives. And in doing an IP audit or review, internal procedures can be developed. Such procedures may relate to IP creation and protection and the identification of these IP assets. For a startup, the main steps may include, in the beginning, company registration, domain name registration, and at this point, from the IP perspective, the main issues may relate to trademarks and initial branding. However, it can also, an audit at this point, albeit early, can also be an opportunity to place a marker in the ground to prepare for IP capture going forward, for example, for a new product development. For a company that already has IP, then the audit can be a matter of considering long-term aspects also of maintaining IP and further developing IP. The IP audit should also consider external factors, including awareness of competitors and the landscape in which you wish to enter with your product and perhaps existing rights there. So alongside identifying and recommending protection for IP, there are important internal kind of factors that will always interact with the IP strategy, relating to ownership and confidentiality and disclosure, the business strategy, marketing strategy going forward, and then rights that are in place. Confidentiality and disclosure is always an important one to consider because, well, it's important that any new product, if it has aspects that could be patentable, those aspects are retained confidentially until a patent application is actually filed. So this slide looks a little bit at how the IP strategy maybe fits in terms of an overall business. A business may have business teams, research and development and marketing, will no doubt impact on timelines for IP processes as well. For example, if a new product is developed, patents may need to be filed before production. Again, further steps may need to be taken on the IP side before marketing and entry into the sales marketplace. And then it's just a little bit of summary of the IP rights, the kind of processes that can be considered internally. IP education, we didn't mention that in terms of audit, but it can also be important to a company in terms of raising the profile of IP internally with employees. For a larger organization, there may be later on an internal innovation policy and culture, and then just other general aspects of a company that will impact on the IP strategy, well, internal employee contracts or contracts and agreements with external parties, perhaps providing consulting. So it's just a little bit of how these various aspects fit together in terms of an IP strategy. So then I wanted to consider a little bit more, in a little bit more detail, each of the different types of the intellectual property rights that are available to somebody that wishes to protect their IP. So it's always, you know, the first step would be to decide what is unique about a product or service that is to be offered, and the most relevant form of IP is that which most effectively protects the unique selling point of what is going into the marketplace. So for example, if your business was making a new type of medical device, such as a glucose monitor, that is seen as more accurate than other monitors on the market, the most relevant part of the IP there to protect would be likely a patent to protect the features that enable greater accuracy to be implemented in the product. But a product like that would also require brand protection in terms of a trademark and possibly also a design. And no doubt there would also be trade secrets relating to testing and different internal functions relating to a product like that. So this is a nice summary table from the UAPO, the European Intellectual Property Organization. It sets out just some of the main attributes of each of the registered intellectual property rights: patents, trademarks and designs. Trademarks, patents and designs in particular are of limited term. A trademark can be renewed over a much longer term, which reflects the growth of the brand and the goodwill that can develop over years associated with a brand. In a little bit more detail, when to consider trademarks? Well, a trademark is a badge of origin by which consumers find your products or services in the market. And since you guarantee the quality of your products, your trademark acts as a symbol of trust that enables your customers to purchase from you again. Once you're using your trademark, the goodwill you generate will be associated with it and build, and in this way your trademark becomes a valuable business asset. From the point of view of protecting a trademark, often trademarks will be word marks and may include logos. If your brand or business name simply describes the goods or services it's meant to identify, for instance, if Apple sold apples, it's not likely to be memorable to consumers and unlikely to be possible to register it. But choosing a brand that has more character makes you more distinctive and helps keep competitors at a distance. So for example, invented words can be very useful for trademarks, such as Xerox, or words that have no meaning in your industry, such as Amazon for online marketing. And generally, a name can be protected as a trademark so long as it's distinctive and you're using or intending to use it in a way that's visible to your customers. A trademark, a registered trademark, is also very useful in terms of offering a level of protection in the online world as well, for your website, for your social media. A design is to provide protection for the shape, color, or material of a product. A design application will normally come at the very end of product development before it's brought to market. And design registration actually can be extremely quick. It can be put into place rapidly. A design application to UAPO at this time would likely be registered within a month. So it's a very quick and decisive way of getting an IP right into place and registered. A patent gives the owner the right to stop others making, using, importing, or selling the invention in the territory in which it's protected. And it generally relates to things that are technical and solve a problem. And a patent application will be examined by a patent office examiner. It will be measured against what exists already in the prior art. And to actually get a patent granted, the invention must be new, inventive, and capable of industrial application. And again, as I mentioned above, very important to keep the invention confidential until the patent application is filed. So there's no need, I guess, with a patent application ever in the first instance to move to cover it in multiple jurisdictions. That can be part of the roadmap for a patent application going forward. Normally, a patent application will be filed in one territory to begin with and then can be expanded further. The timeline indeed can be many years while it's expanded to cover different territories. Just to mention also in passing, we also talked about trade secrets as an unregistered right. Trade secrets are IP rights relating to confidential information which can be sold or licensed. Normally, for trade secret protection, they must be commercially valuable and known only to a limited number of people. And it's important to put in place internally steps to protect the information, to keep it secret. This could be, for example, in terms of confidentiality agreements. And trade secrets are very appropriate for technical information such as manufacturing processes, pharmaceutical test data, also commercial data such as distribution lists, lists of suppliers, advertising strategies, things like that. And also trade secrets would be an appropriate protection for financial information, computer code, formulas and recipes. All those aspects of IP can be protected by trade secret. Also to briefly mention copyright. So copyright is essentially an automatic right. It relates to rights that creators and artists have over their literary and artistic works. It would also relate to computer programs, databases, advertising. Also, for example, these slides, there is a certain copyright in the presentation that would be in such things. So simply to assert copyright, we would advise people to use the copyright symbol and notify people of their ownership in that way. So that's overall in terms of the IP strategy framework, just to loop back in there. We're looking at aspects of the rights, the processes and internal procedures and contracts that can all work together to help a business to protect their IP from the ground up. So. Another important aspect of IP would be in relation to third-party rights. So we've looked to date at protecting your own rights, but nobody really wants to fall foul of somebody else's existing rights in the field. And indeed, from time to time, these stories will appear in the media where infringement actions are being taken. Much better to avoid these kind of scenarios. So we would always recommend that third-party rights are considered and freedom to operate is considered. Again, this fits a little bit into the IP strategy of, in terms of the aspect of having awareness of what is going on in the field in which you're going to be active and awareness of what competitors are doing. Freedom to operate is different from actually being able to obtain a patent for your invention. It is possible that a new invention may be patentable in view of prior art, but it's also possible that a product could infringe on a third party's existing rights. So, for example, if we look at the scope of a granted patent, if the scope of your application, which covers your product, is different, then of course it is possible to get a patent granted. However, if your product was to fall completely within the scope of what the third party is doing, or even partly within the scope of what the third party is doing, then it would infringe to some extent the rights of the third party in the field. Ideally, it's better if the product that you bring to the market falls outside the scope of third-party rights. Of course, there are options available. It may be possible to obtain a license. Rights may be expired. This would turn up in any kind of freedom to operate search or analysis. It may be possible to consider a non-infringing alternative, and sometimes acquisition of third-party rights, or indeed, as we'd sometimes see, of the third party. So from the point of view of freedom to operate, we would always advise having a good awareness of what's happening in terms of not only your own IP position, but what competitors are doing as you move forward with your own development of a patented product or portfolio. So just in summary, some of the things that we've looked at there in terms of rights and strategy. Ownership is a key point when it comes to IP rights, establishing ownership, considering joint ventures, and perhaps covering consultancy. Publication. Again, this comes back to that fatal error that can happen if your product is disclosed publicly before a patent application is filed, then that can limit your rights to any kind of patent protection. The strategy should be developed and grow as the business grows, and should be aligned with the business strategy, and also having a good awareness of what's going on in the IP landscape. So I wanted to look just for the last few minutes a little bit at the digital health aspect. It's a massive field of growth, obviously in your day-to-day, and also in terms of what's happening in patenting. So I provide a link here to a study from WIPO, again, the World Intellectual Property Organization in 2019. They did a report on what had been filed as patent applications with WIPO and other patent offices, and there's a massive bulk and growth in terms of what's called digital health, as digital aspects begin to work together with more traditional health aspects. So some of the fields that they identified are certainly, I think, very relevant to what DConnect are working with in terms of digital aspects of health. We see new ways of delivering healthcare, telemedicine, medicine, remote monitoring, improved data sharing. We see more and more that artificial intelligence is coming to bear on what would have been more traditional healthcare aspects. This is actually an excerpt from patent classification. So in many ways, patent classification reflects the technical world, and we've seen new fields come online in patent classification as new aspects of technology have been developed. And just in terms of digital health, I was looking here at the new fields in classification relating to computer assistance and how data is working together with digital health. And this is a field that in recent years, even in very recent years, has seen thousands of patent applications as the activity grows there. We see this is a word cloud that comes from an analysis or a breakdown of the content of those kind of patent applications, and we see themes around user interfaces, mobile, datums, and so on, a focus on the data that's working in the digital health sphere. And again, this is similar. So as we look at digital health, I think in some ways, in a very simplistic way, really, you can see how these traditional stakeholders, patients, users, maybe medical device and pharmaceutical companies and providers and so on, are building more and more data backend aspects, and hand in hand with the traditional aspects, data processing, and that this is bringing together a whole new sphere of developments in terms of technology. So as mentioned from the WIPO study, some of these aspects would be remote patient monitoring. There are companies active there. Wearable and fitness technology. I think basically everybody has a Garmin or Fitbit or some alternative nowadays, and also telehealth. And all these are aspects that we are seeing covered with patenting, trademarks and designs as well. So I wanted to take a first example, an Irish company that's been operating since 2013 and has a number of digital healthcare solutions in the marketplace. If we look at, this is from HealthBeacon's website, they have a product relating to management of injectable medications. And indeed, there is a device and there are data aspects and user interactivity aspects as well. So if we break down just a little bit in terms of analysis on a very broad level of what's going on behind this, if you like, digital health solution, we can see data processing aspects, connectivity devices, waste management, and patient training and support. And indeed, we can consider then the mapping of IP that would protect these. Data processing, well, trade secret, connectivity and devices, most likely to be patenting, waste management, again, likely to be trade secrets, and into patient training and support, you would be looking at, well, aspects around trademarks, branding, and copyright. Mentioned there briefly already, Fitbit and Garmin, they literally have hundreds of inventions, but it's interesting to see that they protect their work using designs and patents. Also Garmin, they have a certain body of designs in addition to their patented technology. So from Garmin, we would see that they've used, for example, a design application to protect how one of their fitness watches looks from various angles. They also have patent protection for the more technical aspects, a trademark, and then also a lot on privacy and data management. So in summary, I would always suggest, especially in digital health, that maybe more than ever, the different types of rights will come into play when you go to protect your IP. Just a little bit to mention on the support side for companies operating in the digital health sector, or indeed any sector, for SMEs. On the IP side, I guess hand in hand with the studies that have shown perhaps a lower uptaking of IP among SMEs, the EU has put into place an SME fund, which is managed by UAPO, which can be used by any European SME can apply to obtain funding towards having an IP audit done, or funding towards fees for trademarks or designs. The Irish Patents Office website also has that. I would also say that in Ireland, we're lucky to have Enterprise Ireland, who have a very well developed IP support unit for Enterprise Ireland clients. And then I did notice that the Irish Patent Office do have a nice summary of the various places that and resources that people can look to as they move to develop their IP. Finally, one last thing I wanted to say. So IP, I guess it is nuts and bolts, and it's often existing quietly in most of our lives until we need maybe to protect an invention or consider IP rights. But in fact, there will in Ireland in 23 or 24 be a referendum on IP relating to a new unified patent court that is to come into operation in Europe. Ireland do support it and have signed up as wishing to participate. It's going to be a new court and new IP rights to allow users get a European-wide right, similar to the current trademarks and designs that are available on a European basis. But anyway, the Irish public will need to actually vote on that so that Ireland can move forward and participate. So I expect in the near future, we'll be hearing a bit more about IP in our day-to-day lives as well. So that's all I have to say. Thank you very much.
Thank you, Catherine. That was very interesting and very applicable to the startups that we work with. I love the way you brought in the medical device categorization, and the word cloud made it very visual for us to be able to see what exactly is going on at the moment in the digital health area. So thank you for that. Certainly answered a lot of the questions that I had around IP and patents, and I'll be able to pass on that information now to our clients.
Okay.
So I'm going to pass over to Connor. Before I do, I'm just going to show you a very short video on 3D printing in healthcare so that you can get a visual of why Connor's journey through IP and patents with the 3D printing company that he founded is so applicable to yourselves as digital health founders. So I'm going to show you the video now. Connor, will you please let me know if you can hear that?
No sound yet, sir.
No sound. Okay, let me just check. Okay, I'm just going to try that again. I'm just going to try it once more, and if it doesn't work, I won't spend too much time on it. I can share the link with you and you can have a look at it after the webinar. So let's try this again. You hear that sound, Connor?
No, but the video is coming in slowly.
The video is coming in. Okay.
It's actually stopped now.
Okay, so okay, I'll play the video so we can get a few visuals of health items that are printed using 3D printing. Okay, that didn't go so well, so I'm just going to leave it, and I will put the link into the Q&A and sorry, into the chat so that you can see it. And I'm going to pass over to Conor. And Conor, will you please introduce yourself and let us know how your journey went through IP and patents, warts and all, because we always like to hear what life was really like in the trenches. Thank you, Conor.
No problem, Sarah. Plenty of warts in this story. Yeah, so will I share my screen? Do you want to disconnect yours? Yeah. Great. Okay, so thanks, Sarah and DConnect for the chance to be in here today. Obviously, as Sarah mentioned there, my story through this is going to be more of a kind of a practical experience of what we experience with the company. So talking about intellectual property and patents, my name is Conor McCormick. I am the founder of a company called Ad Astra Consulting, and we consult from everything from machine design all the way to business strategy, from startups to very large companies. So that's currently what we're working with. But my background a little bit, I have a PhD in mechanical engineering from Trinity College Dublin. I worked with Airbus on part of the design of the A380, worked with companies like Boston Scientific. But the reason why I'm probably here today and asked to come in and talk a little bit today is that I was the founder and former CEO of MCore Technologies. While with MCore Technologies, I helped to raise over $20 million, eventually through venture capital funding. And relating to today, we had 13 actual patent families, 17 of which had gone through various countries and been granted. We had trademarks, we had trade secrets, we had design patents, so up to around 19 or 20 different intellectual property families in the business. So what I'm going to go through today in 10, 15 minutes is just literally talk about the background about the company, how our IP journey started off from the very first patent, and then how it kind of led to how we cultivated the IP. As Catherine said earlier, companies had it when they get more mature, they look at things differently between trademarks and different IP. A little thing about the financial aspects of the patents, and then some common IP themes. So we work a lot with Enterprise Ireland startup companies as a mentor, and we get a lot of kind of common questions coming up about IP, and I just wanted to share some of them. And then finishing off with the investors, how important are patents to investors from my own experience when we went through with the company. So without further ado, MCore background. So we had developed the world's first full color desktop 3D printer. We had won the Innovation Award at CES 2016, an Edison Award. We had a lot of media, Fortune magazine. The machine was designed by MCore, but it was manufactured by Flextronics, powered by the print engine by Funai. And Funai, you might not have heard of, but basically that's the Lexmark 2D printer that you might have in your office is actually owned by Funai, a Japanese company. So that was powered by the print engine inside. We sold into 50 different countries through 150 dealers. And some of our clients, we had very blue chip, Boeing, Honda, NASA, Samsung, Nike, Apple, and it was all around printing a full color object. And obviously that video that we tried to have, Sarah tried to run there are some aspects of medical 3D printing that color is important, but probably more so, especially when you talk about implants, it's about the the certification of the material, what material can go into the body. There's lots of different applications, not only inserts into the body, but product design where 3D printing is important. For us, it was all about a low-cost color 3D printer. And this is at the very start. We were the first 3D printing company in Europe. Believe it or not, our only competitors were American companies. So we were at the very bleeding edge of 3D printing technology. And when people talk about an in-house product, people say, well, we have an in-house design. Ours was actually in-house. It was in the front room of my house. Here you can see the very first machine that we built, my brother and I and my wife on the marketing, where we built up this business from the scratch. And how did we go from there to being manufactured in a company like Flextronics? Here you can see for scale, a person standing here, a top 10 tier 1 manufacturer. How do we kind of entice them, and how do we manage that whole thing? Was a quite interesting journey. In our roadmap, we had 4 products in the time with MCore, looking at the years on the bottom and the number of units sold here, potential in the y-axis. The generation 1 at the start of 2007, generation 2, the Mix 300 at the end of 2009, generation 3, the Iris at the end of 2012, and you can see the number of units that we were selling per annum. And then finally, 2016, the Gen 4 ARC machine, which was manufactured in Flex. So we went from a machine that literally we were putting together by hand, moving all the way up to outsourcing the manufacturing to a company in the UK. Unfortunately, we couldn't find one in Ireland at the time. And then eventually the machine was manufactured in Poland through Flextronics. So that's really, we had a lot of IP all the way through here. I'll highlight now one of our first patent and how it actually went through all our products. Something that we thought would be, okay, we need to get a patent file here, but it actually became intrinsic and an critical part of our business as the business moved along, all the various different gens that we had. So our own IP journey, just to share what it was like for our company. So the very first patent. So we wanted to, very boldly, we wanted to revolutionize how people designed and innovated in the future. So if people are familiar with 3D printing and maybe the whole movement and MakerBot and how that all started and RepRap, this was before any of that. So nobody was doing this on a kind of a hacking level. We had exposure to very large end 3D printers at the time that were over 100,000 each. That was the lowest machine you could buy. And the cartridges that went into them were thousands of euros each. So quite easily a company could be spending 50, 60, 100,000 a year, or some were doing it even per month on their 3D printed design. So we wanted to change that completely, put it all on its head. And we said, how can we do that? So we wanted to use a water-based adhesive and paper. So even though paper isn't that structural, although it can be very strong in compression, and we lots of people use them for molding later on in the development of the product, we wanted to make a very low cost and a very green, eco-friendly product. And that's what we come up with. So we said, okay, stick and paper and water together, that's simple. We won't even worry about that. That must be done thousands of years. People making origami, we've more important things to worry about trying to build this machine. However, it turned out to be the major stumbling block in getting it to work, to such a point where we're actually told that it's impossible by a global adhesive manufacturer, that what you're trying to do is impossible. You will not be able to put a water-based adhesive down on a paper without it getting blistered and all the kind of nasty things that would happen from that. So we spent about a year just with our doors down in the industrial unit that we had, and we just worked developing a very small team trying to solve this problem. So we weren't thinking about IP, we were just thinking about how we're going to make this machine work, how is it going to happen? And we come up with this device here. It's a device that enables us to deposit at a very precise, in picoliters size, very viscous adhesive. So the adhesive that we were depositing was around 1,500 centipoise. I'm sure a lot of you will know what that relates to, but just to give you an idea, ink is under 5 centipoise. So something that in your printhead that actually jets out ink on a page can only manage something up to 5 centipoise, and we were doing 1,500. So we had developed something that was very unique. As Catherine said earlier, uniqueness is a key part to getting IP across the line. But we solved it really just to make the machine work. We wanted it to work. How is it going to happen? And then from talking with Catherine and Barry from the department attorneys, looking at what we had done, they really got it across the line to get our first application in. Of course, our first patent was very much us doing very detailed technical descriptions as an engineer would, technical drawings and explaining all of everything, how it works. And I think then the real skill set of the patent attorneys to come in and really make that as broad as possible. And that's a big mistake I think some engineers make, or technical people filing patents. You really do need to get a very broad application into the process. So our own process is that we would start off going to the UK Patent Office. We would get, it was cost effective, but we get a report back within 6 to 8 months. We would then examine the feedback. We would decide that we need to make modifications, and we would make a go, no go decision at that point. And then for us, we would file a PCT filing. And the PCT filing would give us worldwide protection. It would delay the costs, which I'll talk about in a moment, and it would also postpone the decision on the individual jurisdiction. So where we wanted to cover, this would enable us to kind of wait a little bit until we knew what countries are really this is going to be very successful in. And that's actually one of the things where people sometimes can file a little bit too early, and I'll just mention that near the end. So for us, the PCT process, if you look at the time scale in months, so you start off with your initial filing. Just before the 12-month period, you would do your PCT filing, and that would give you another 18 months. So you have in total between 30 to 31 months. And at this point, then you have your national phase deadline. So at this point, you have to file for your corresponding applications in whatever countries that you want to go in. So as you can see, it's very spread out. It gives you time to decide where you want to go, but also it delays some of the costs, which is great for a company that doesn't necessarily have a lot of money. It's kind of a chicken and egg thing. You do need IP, especially for us with a product, to raise serious financing. But without serious financing, it's very hard to actually generate, to file for the IP, because it can build up. So this was the process that we went through. Looking at the end here, but what countries and what areas to file, that's another question that we get asked a lot. What countries should we protect? And Catherine went through it, showing a map there. But for us on a company level, the way we did it is that, again, we looked at the map of the world, and we broke it up into 4 different regions. Firstly, we looked at color coding here. We looked at the top 3D printing countries. So for us in Europe, it was UK, Spain, France, Spain, Germany, and Italy were the top 5. And of course, America being nearly 30 to 40% of the market in one country, we had to protect that as well. So they were the first areas that we needed to protect. The next area was any of the main shipping ports. So if you didn't have them covered already, like for example, Holland is a very big shipping port for shipping into Europe. So no matter where your product was coming from, it might come in through here. So we wanted to protect that. Also, some rapidly expanding areas. So some of these countries, their initial filing aren't that expensive. So sometimes it might be worth your while, like obviously China, India, Brazil. The number of engineers and the number of 3D printing machines that were coming from these areas was exponentially growing. So we felt we needed to protect there. And then finally, some barriers to entry. So we had been talking to some extremely large distributors who would have made a huge game-changing difference to the business, and they wouldn't take on our product unless we had IP. So we had some of those earlier discussions, and we knew that was a concern, which is an interesting angle for intellectual property, having filing patents. Sometimes countries and big dealers, distributors won't take you on because they'll say, why am I going to invest money and time into this product when just when we do that, somebody's going to copy it because you've nothing to protect. So that's how we chose what countries to work on, and that's how the IP went out through the PCT. In terms of the timing, I think this is interesting as well. Catherine had a similar slide about R&D phase and then a commercialization phase. And when we plot the patents that we filed and our trademarks over the years and the number of the frequency of filing. So here is the number of patents that we filed. Obviously, we're not as big as, the company was not as big as Fitbit or Garmin, but we had one patent filed in 2007, which I highlighted there, the adhesive deposition device. And then the next patent we filed wasn't until 2012. We did 1 in 12, 1 in 13, 2 in 14, 6 in 15, and then 1 in 17. And if you look then how the trademarks, nothing until 12, then 2 in 14 and 1 in 15. So when you look at these, there's kind of two obvious things that happen. We got investment, we got high net worth individual investment around 11 or 12, and we got venture capital funding in 14. And that enabled us to actually say, okay, now we're really commercializing with this new product. We're going into our Gen 4 machine at this point here. This money was raised to generate the Gen 4. And we really need to commercialize it. We're at the other end of that, and so let's really protect it. And one of the things that we did was how do we cultivate the existing IP that we had? So that leads me into this section. And another way to say it would be to circling the wagon. So how, you imagine, how would you circle your own IP and protect it? Both internally as the ones you can cultivate from what you've already filed, and looking from the outside in, what are any gaps that you need to kind of fill? So there's kind of a two methods in the methodology that we use. So the first one, method one, was to look from within. So we identified key areas of our existing IP, and we would say, well, the machine will not work without this. So there might be things that the engineering team has developed over the years, believe it or not, that, well, you just solved the problem. You didn't realize that you're really, it was patentable. You're just like, I have an issue here and I need to fix it. And then when you look into that, actually no one else has ever done that. And there could be IP looking within. Ask the question, what does it solve? That's another way to kind of look at internally. And then the other way would be any ideas that you come up with, but you discarded. So say they lost out when you did a matrix of cost benefit analysis, or wherever it might be on the other ideas. So it might have come in number 2. So you obviously went with number 1, but could somebody else look at these? If they filed a patent on the number 2 ID that you came up with, would that be a problem for you? If it would, we then looked at IP around that. Method 2 would be to look from a competitor's viewpoint. And this is a very interesting, and for people that like to invent, it was a great fun exercise. You start off with a blank page. You basically think, how would a competitor compete against your own company? So it's quite hard to do sometimes because you really are in the trenches and you only see your own design, but it's a very good process to do that, to look at what your company does and how would you compete against that. And if there is something there, then maybe that's one of the gaps that you need to file. So it's more of a protective IP. You might not necessarily go down that road. You could, but it would stop people coming in and taking some of your revenue in that field. And here's where the patent attorneys really can come in as well and challenge these ideas. So you obviously get to the point where near the end of generating IP with MCore, we used to, I don't know if this is, Catherine can confirm or deny this, I don't know if this is normal, but we used to be more, we would generate a concept, we would do drawings up, and then almost just outline how it was different, and then very quickly go to the patent attorneys, Catherine and Barry, and say, this is what we want to file, and it would then be very generic from that point, and that we felt that was a very strong way to do it because it was less technical detail, but we had already made it work. We had it actually working in the lab, which is a big important point. Just to touch on the financial, two things I wanted to mention here. One is that the costs are phased. And secondly, a thing that we found was very useful near the end of MCore was to have some sort of a plan on the financials. So the first thing about the phasing, and just to caveat this, these numbers are not accurate in terms of the value, but just to give an idea of timing. So if you had one patent and say you're going to file this month, I'm not sure the exact filing cost, but say I'm going to file, and then you say, right, I get some feedback come back from your patent search. I might have to do some work or review around that. There might be some more costs. And then before the end of the 12-month period, I'm going to go to PCT, there'll be a PCT filing, and then there'll be subsequent kind of costs as you move along. So as you can see, it's a very phased cost incurred to the company. So that's an important point when you're talking to, if you're considering IP. And secondly is about planning. So you can imagine if you had 6 or 7 or 20 patents going through various stages from initial filing to various jurisdictions, the cost can kind of rack up. And with your patent attorney, you should be able to list all your patents. I find this very useful, and get a kind of a page holder of what the cost might be and when that might happen. So you can kind of plot that into your calendar going forward. So you can kind of say, okay, I'm going to have a lumpy bit here next November. And it's very nice for the financial guys to be able to say, okay, this is happening down the line. So you're not just hit with a big bill that nobody expected. Okay, so second, lastly, I'm just going to talk about some common IP themes. So we do work with Enterprise Ireland companies, and from a whole range of very startup ideas to a little bit more developed, but it's surprising how many of the same kind of questions that we get over, and I try to condense them into a couple of points. First one is, can I file? You get the statement like, I won't get a patent because a machine like this already exists. And if you remember going back to the very first idea, our first patent was around a device that deposited a very viscous material that enabled us to use a water-based adhesive and paper. So we didn't actually file on a 3D printer. We filed on a device using this MEMS device inside it. So we meet companies who have developed something inside that is really kind of innovative, but they feel, well, I don't know if I can get a patent for it because I didn't invent the entire thing. But actually, when you go and talk to patent attorneys, they'll actually be able to tease all that out. So a lot of times you can. When to file, it has happened, and where people actually can file a little bit too early. So you might file maybe in Ireland or the UK or whatever country you're living in, and you haven't made the decision because you don't know if the product has legs or if you have the financing. And before the 12 months are up, you haven't filed for your PCT, and then you're kind of in that country. So you have a patent maybe or applied for in that country, and you will not be able to move that on to a PCT. You'll be referring your own patent in prior art. Catherine can confirm that or deny that. But another thing, as Catherine mentioned, is that you need to file before you have any disclosure. So that includes any presentations that you might give to an audience at a public kind of event or a trade show. So a lot of times that's a forcing function. It happened to us, I know, a few times where we might have to go to a trade show. We're launching something, and we would have to get our IP in line and file before that actual event. What to file? So remember, the application should really be as broad as possible, and not a minute detail engineering description, which is the problem that us engineers have all the time. And I think it's a skill of the patent attorney to kind of really see the value in what you're saying and actually help write the IP correctly. Our patent's expensive. I'm not filing. I can't afford 10, 15,000, whatever it would be right now. But as you've seen in the previous slide, it is very phased. They are expensive, and they get more expensive as you move along, but they're there. IP is there for you to exploit and to make money. So you will be generating money. And if you are generating money, you can afford to pay it. If not, then maybe you need to look at some of your IP should you be protecting it. And finally, do I need patents? So I would say if it's a physical product and you're going to do some fundraising, I would say yes. There are some circumstances where you have a lot of trade know-how, trade secrets, and actually they're so sensitive that you might be better just to keep it completely quiet. As long as you can show that and its value, you might have a case for doing that. But anything that's a product where people can actually go and look at it and interrogate it and buy it and maybe try and reverse engineer it, I would say you need to have patent protection. And really that leads on to the last section, which is in terms of the investors and how do investors view IP from my experience of the fundraising that I went through. So before I do that, I just want to show you one slide. So if you think about the value proposition matrix, and we do this with some of the companies that we're working with. So if you look at the value of your product plotted against how unique it is to your competitor. So there's kind of 4 zones that we're going to look at. So the first one is that it's not valuable or unique. So you're in this zone of a non-valuable, non-unique product. This product is going to be insignificant. Next, if it's still not valuable, but it's unique, so you have a very unique solution, but nobody wants it, then the market for your product is going to be very poor or no market for it. Over here is where you want to be. So you have value, but it's not unique. If that's the case, then unfortunately, pricing strategy is the only way to get this product out and sell. And finally, you have a valuable and unique offering. And this is where your product can be a big success. And this is your ideal location for your product. So you have a valuable and unique offering. So why is this important to investors? So the investor's going to put money into your business and they want a return, bottom line. And the more unique it is, the more protection. If it isn't unique, it becomes valuable, but it's non-unique, and you're down into the zone here, and it becomes more of a fight to get the product out there because the uniqueness isn't there. So you really want to keep up here. And how do you maintain uniqueness? You file IP, and that's really why investors like IP. So just to share with you finally our slide. So we would have a slide like this in our pitch deck about high barriers to entry, and this is what we would show to an investor to show that our IP and our knowledge and our trademarks are protected. So we would have said something like, we have patents, we have 13 worldwide families, 4 families have been granted and 17 to date. We had 9 families in this classification, the B29C, which is a 3D printing classification. Within that classification, the most prolific inventors were my co-founder and myself. The most patents in that classification, first was Canon and second was MCOR. The number of patents filed in 15, Canon and MCOR had done the same. We had trademarks, 4 families granted, families 11 to date. We had a design patent, 1 had already been granted. We had trade secrets, which, we explained a little bit about what our trade secrets were. We had proprietary software, which was fantastic because it was not only hardware, but it was a software play. And then finally, we had 12 years 3D printing engineering know-how built up in the company, which was extremely valuable for the investor. So that's really how we would have pitched it. And I know from every time, it's one of the first questions that you'll get, is it defendable? Can you protect your idea? So I would say it's a very important factor for an investor. So that's been my journey through the IP landscape. As I said, it was a very exciting one. Now you can go to our website if you want to look and see what kind of work we do. We do have companies do something similar to this, product design and business strategy. But I'd like to thank you for your time for listening. I hope you found it informative, and I'll hand back to Sarah.
Thanks very much, Conor. That was super. Really enjoyed listening to your story, and again, very visual, so very easy to follow. Catherine, maybe I'll ask you to put your video back on now as well. And I just want to thank our attendees for staying on, because I realized that we've gone into your lunchtime. So I presume that you found all of this as interesting as I did when you did stay on. So Catherine, you did mention funding, EU funding. And Conor, you'll know from being an inventor that your patents cost you a lot of money, your cybersecurity cost you a lot of money, your data protection statement. All of our founders have so many outlays that are absolutely critical to the success of their business. Did you find that Enterprise Ireland, or with the companies that you work with now, Conor, do Enterprise Ireland offer any support in terms of filing for patents?
Yes, I mean, as Catherine said, EI have a very good body there that looks after. You have to be an EI client, that you see. You have to be in the door, as you say. But once you're in, they have a very good support and a good network. And there's a great guy in there, Joe Doyle, I think his name is, and he's a real champion for IP and what happens. If you're not in the system, it's a little bit harder, but there probably are other support systems out there. But we're very lucky if you, like with Catherine and Barry, some of the companies will actually take a punt on you And that's really what happened with MCOR. So they were very kind of good for us, you know, very early on at the start when we knew we didn't have a lot of money. And then, you know, we were able to, you know, kind of pay properly when we actually had proper investment. So, but there are supports within the Enterprise Ireland ecosystem, and there probably are some outside.
Okay, and a question I would have for you, Conor, is from filing a patent to getting the patent, what's the timeline?
Oh, I was amazed at that myself. I mean, our initial filing was in 2007, and it was years later before our first kind of patent was actually granted in the first country that we kind of chosen. So you'd nearly forget about some of them. And they're out like little children running around all these different countries. And then the other thing, there's a lot of kind of to and fro between yourself and the patent attorney, where some particular country, some patent review in, say, China would find something that maybe somebody in a different country hadn't found, and you mightn't have been aware of it either, and you'd have to look through their patent, find out how yours was different, and then explain that to them through your patent attorney. And so there's a lot of kind of work as well throughout the process to make sure you kind of handhold each patent through the various countries. Sometimes you get them through, but it would take years. Catherine would know better, but for me, it was years before our first patents went through.
I guess that's a very good way to do a very in-depth competitor analysis as well, if you have to dig that deep to find out what your competitors are doing. Catherine, over to you.
Oh, no, I was just going to say, I guess at least 5 years would be a typical timeline for getting grants. So there are mechanisms to speed things up or slow things down. Sometimes applicants prefer to keep things pending, to keep options open and so on. But I think 5 years, or at least 5 years, is a good guess there. So on average, yeah.
Okay, and for our attendees, would anybody like to ask a question? You can come on the mic, raise your hand, or pop it in the Q&A. So I think, Catherine and Conor, that's our questions answered for today. I'm delighted. I know now when we have clients who have questions around patents and want to file for patents, I have a consulting company that I can call. I have a patent attorney that I can call. So that's fantastic for us in DConnect to have made those connections. So thank you very much for your time today and for your sharing your information so generously with us. And I'm sure we'll be in touch in the future around this topic. Thank you.
Yeah.
Thank you very much.
Sarah.
Enjoy your lunch.
Bye-bye. Bye-bye.